Hi, I'm Esther. I was a defendant in a couple of recent defamation proceedings in New South Wales and Queensland. This presentation runs through some basic concepts in Australia's very technical defamation laws.
If you need a lawyer, I personally recommend this firm, O'Brien Criminal and Civil Solicitors. They represented me in the final stages of the defamation actions that went rather badly for the plaintiffs.
Australian defamation law has come under a lot of criticism in recent years for its chilling effect on free speech and journalism. Some people think that it's unfairly weighted in favour of plaintiffs, and particularly wealthy ones. The costs of running legal proceedings for defamation are extremely high.
I'll be talking about what defamation is, the judicial avenues for dealing with it, some basic legal concepts within defamation law like publication, identification, imputations, and damages. Then I'll run through the main legal defences for defaming someone.
If you want to skip ahead, I've put some time signatures below this video in the About section on YouTube with some links to some further materials available online.
You need to be aware that you can be sued for nearly any kind of communication. That could be a Facebook post or a comment, a tweet, an article or a blog, an email, a pamphlet. And you can end up paying a large amount of money in damages, even when you've defamed a person to a relatively small number of people. In this case, the defamatory email was sent to 35 people. In Part 2, I look at a case where a person was awarded $120,000 over an email sent to 17 people. If you lose a defamation case, you're likely to be ordered to pay the plaintiff's legal costs, and sometimes those costs can exceed the amount you have to pay in damages.
If you don't want to watch any further, but you want to say something controversial about somebody, I highly recommend that you stick to facts.
That is, don't say anything about anyone that you can't prove. Ideally, that means being able to prove any allegations with reliable and willing witnesses or documents capable of proving something as fact. Don't just repeat stuff you've heard. Be careful of stuff you read on the internet that doesn't come from a reliable source.
Can you prove what you want to say?
If you attach a controversial label to somebody, can you prove that as fact? Sociopath, evil, criminal, liar. Those kinds of labels are difficult to prove. At the very least, if you want to express something as an opinion, you must show a proper and rational basis for that opinion. That is, renowned facts or proper materials. You also have to identify those facts and materials in your publication. That gives the people you're publishing to an opportunity to decide for themselves.
As to my background, in September 2018, the defamation case of Benhayon versus Rockett went to a 6-week trial in Sydney.
It was a case where I published about a cult, Universal Medicine, and its leader, Serge Benhayon. He claimed I damaged his reputation by publishing a blog article, some blog comments, and 17 tweets.
I won that case, and in the process of defending it, I proved 36 very serious imputations about Serge Benhayon are substantially true.
Those allegations include that Serge Benhayon is the leader of a socially harmful cult. Serge Benhayon had intentionally indecently touched a number of his clients in his treatment room. Serge Benhayon has an indecent interest in young girls as young as 10 whom he causes to stay at his house unaccompanied. Serge Benhayon is engaged in a healing fraud that harms people. You could say his claim backfired badly and brought a lot more negative attention to him than my publications ever did. He has since been the subject of unprecedented scrutiny in the press, and he was ordered to pay my legal bills.
But defamation cases are not fairy tales. Even though I won, I was bankrupted by the 2 proceedings, and it will take me some time to recover financially.
If you want to know more about my successful defence and get the full list of imputations I proved true, look for this blog. There's a link below this video. I recommend that you carefully plan before you speak out about people who you consider to be disreputable, and you should be particularly cautious if they are corrupt or have antisocial tendencies. Some of these people tend to bear grudges, and if they are wealthy, they will use their resources to retaliate. In this case, politician Eddie Obeid sued Fairfax Media and its top investigative journalist, Kate McClymont, for defamation. Even though he won his case, he was later jailed for corruption. Unfortunately, there's no redress for Fairfax's failed defence. In some cases, plaintiffs use defamation law to attempt to censor critics. You could reasonably assume that people like Obeid and Universal Medicine's Serge Benhayon use defamation litigation not to vindicate their reputations, but to prevent the truth from coming out. The term for that is SLAPP, Strategic Litigation Against Public Participation. These are legal actions taken by powerful people and organisations, often commercial corporations. They use the legal system and their wealth to intimidate whistleblowers, journalists, and critics. Defamation actions are one way they do this. In 2019 in New York, the hierarchy of a cult known as NXIVM, including its leader Keith Raniere, were convicted of various crimes around sex trafficking, slavery, and fraud. But in the decades prior to that, the cult had spent millions suing whistleblowers and journalists, bankrupting some of them. Defamation complaints are usually handled via the civil courts. A plaintiff will go to court and file a claim. If a defendant wants to avoid paying money to the plaintiff to compensate them for damage to their reputation, plus the plaintiff's legal costs, they must answer the claim by filing a defence and persuade the court that they published within the law. It's possible to make a complaint to the police of criminal defamation. However, these charges and convictions are rare. You might want to look at the Crimes Act in your state to find out the parameters of the criminal law. The law is similar in all of the states, but using the New South Wales Act as an example, in section 529, a person who, without lawful excuse, publishes matter defamatory of another living person, knowing the matter to be false, and with intent to cause serious harm to the victim or any other person, or being reckless as to whether such harm is caused, is guilty of an offence. Maximum penalty, 3 years imprisonment. And where the Act refers to lawful excuse, it's referring to the legal defences available through the civil courts under the Defamation Act of 2005, which I'll talk about in a moment. There was a recent criminal case in Queensland. An elderly man put pamphlets in local letterboxes that alleged his former bowls partner was a pedophile. He knew the allegation was false. What he did not know was that he could be charged with a criminal offence for maliciously defaming another person. But ignorance of the law is not considered to be an excuse and won't stop a person from being charged or convicted. He pleaded guilty at the first hearing, and the case has not yet concluded, so we don't know about the outcome in terms of any sentencing. Sometimes people are confused by what constitutes defamation. I've heard some people say that a statement is not defamatory if it's true. That's not correct. Under defamation law, a publication is defamatory if the publication tends to lower a plaintiff's reputation in the minds of right-thinking, ordinary members of the community. I encourage you to read the Defamation Act 2005. You'll see it referred to state by state, but it's a uniform law around Australia. Or at least read the articles about defamation on the internet written by qualified people. Under the Defamation Act, there are legal justifications for defamation in certain circumstances. If you read the Act, Section 3 is about its objectives. The law aims to balance the interests of free expression on matters of public interest and importance with a person's right to protect their reputation.
So what is publication? A person can only be held liable for defamation if it's proven the material was published to someone.
Publication occurs when the statements are read or heard or seen by somebody. The publication can be any medium of communication, an article, a blog, a tweet, an email. It might be a recording or broadcast on radio or television or social media. A plaintiff can't claim they've been defamed if no one read or saw or heard the defamatory matter. The plaintiff must prove publication. You don't need to admit to publishing something unless or until the plaintiff shows proof that the statement was in fact heard or read by someone. They must identify those people. Defamation claims must be filed within 12 months of publication, but you can be held liable for a publication originally published years before if it's proven that someone read or heard it in the past 12 months.
You might send a letter to someone, but it's not published until someone opens the letter and reads it.
The plaintiff must be identifiable in the publication. Even if you don't use that person's name, other things in the publication might identify the plaintiff. This has happened where an image of an Aboriginal child was used in a newspaper article about juvenile crime. The child was pictured standing behind a chain wire fence, but the child had never been involved in any crime. And after the article was published, that child was subjected to ridicule and contempt. Mostly individuals sue for defamation, but small companies with less than 10 employees and non-profits are also able to sue for defamation. Looking at a New South Wales Court of Appeal judgment, a defamation case brought by the Exclusive Brethren organisation was thrown out of court in 2018. The judge relied on Section 9 of the Defamation Act that says that certain corporations do not have cause of action for defamation. But the decision was overturned on appeal. This also raised the principle of identification. The corporation was a separate entity to the organisation's church. Reading from the judgment, a reasonable reader could not infer that any of the allegations in the matter complained of were about the corporation. Read as a whole, the matter complained of plainly referred to the church and its elders, rather than the corporation. As an alternative to a defamation claim, companies or businesses can sue for injurious falsehood if a person publishes false statements that cause financial loss. This is similar to claiming damages for defamation, but the focus is on economic loss, and the party suing has to prove the financial loss. You'll hear this term used a lot. Imputations in defamation law are the allegedly defamatory meanings that are conveyed by a publication. And as it reads here, attributions, ascriptions, accusations, insinuations. The plaintiff decides what the imputations or insinuations are. The imputations will be pleaded in the statement of claim they file with the court. The imputations might not be the words you published. The plaintiff might claim that your publication carried insinuations that you did not mean to make. You may have to defend and sometimes prove the truth of an imputation that you did not intend to convey.
This is one of the issues in defamation law that critics think needs to be reformed. It's where the law becomes technical, and it's where people can have disagreements about what words and terms mean. Often the court will hear long arguments about the meanings of words and terms. Now, an example of this might be people's understanding of what the term sexual abuse means. Now, some people interpret that as only meaning abuse involving physical contact, whereas I tend to adopt a more general definition of what sexual abuse is, and I think it can entail things like revenge porn or viewing somebody, viewing images of somebody, or viewing somebody engaged in sexual activity without their consent. It could also involve a person speaking about, speaking gratuitously about sex or sexual violence in front of children. Those are things that I think fall under the definition of sexual abuse, but there is a lot of disagreement about that kind of thing.
This is a remark by a judge. It is the function of the court to determine whether imputations that have been alleged by the plaintiff are carried by the publication. From the position of a hypothetical character referred to in the authorities as the ordinary reasonable reader. So it's the job of the court, in my case it was the jury, to decide whether the meanings were found in the publications. Is the imputation conveyed by the publication? This is another remark by a judge, and I'm using judges' remarks to show the precision they use when giving reasons for their rulings. The plaintiff must satisfy the court on the balance of probabilities that the hypothetical ordinary reasonable viewer would understand the publication to have the meaning alleged. The plaintiff bears the onus of proof. Justice Mossop then elaborates. The distinction needs to be drawn between a viewer's understanding of what the publication says and the conclusions which the reader may reach as a result of his or her own beliefs and prejudices. An imputation may arise if the ordinary reasonable reader would understand it in that sense, drawing on his or her own knowledge and experience of human affairs. In the majority of cases, whether or not the imputation is conveyed is not decided until all of the evidence is heard, and the question of whether the meanings are defamatory or not is not decided until that point either. In my case, the jury decided 16 imputations were not carried, but by then I'd gone to the trouble of bringing evidence and argument to defend them. I think that's an area for law reform, because if those issues could be decided before the trial, it would save the time and expense of defending imputations that are not conveyed. In part 2, I talk about a case where TV personality Don Burke was sued for defamation. In that case, his lawyers applied to the court well in advance of the trial to rule on the question of whether the imputations were conveyed. As it turns out, the imputations were not conveyed by the publication, and that ended up saving the parties the time and expense of preparing for a trial. The judge or jury must put themselves in the position of the ordinary reasonable reader when they decide whether an imputation is conveyed by a publication. The ordinary reasonable reader is of fair or average intelligence, is a fair-minded person, is not overly suspicious, may engage in a certain amount of loose thinking, but is not avid for scandal, is not naive, does not search for strained or forced meaning, reads or views the entire matter about which there is complaint, and considers the context as well as the words alleged to have been defamatory.
In my case, my lawyer told the jury that they would have to imagine themselves as the ordinary reasonable reader, because the ordinary reasonable reader usually just reads something once and they're not called into court and having to listen to lawyers argue, sometimes for days, about the meaning.
There are tests for the court to decide whether an imputation is defamatory. For example, an imputation is defamatory if it's capable of exposing the person to ridicule or lowering the person's reputation in the eyes of members of the community, or causing people to shun or avoid the person, or injuring the person's professional reputation. Damages are assumed in defamation in Australia. In other words, the plaintiff doesn't have to prove damage. There is a cap on damages in Australia. The current maximum award for non-economic loss in the New South Wales courts is $407,500. It's the judge that makes the decision on how much to award a successful plaintiff, and that can be anywhere from nothing to the maximum award. The UK law is quite similar to Australia and used to work on the basis that damages are assumed, but that was recently reformed there and resulted in a drop in the number of defamation claims. The UK introduced a serious harm test, which means that a claimant must prove that a publication has caused or is likely to cause serious harm to their reputation. In the US, the onus is on the plaintiff to prove defamatory statements are false. Furthermore, public figures have a higher bar to prove libel than private persons. A public figure has to prove that a publisher of false statements acted with actual malice. Actual malice means that the publisher either knew that the statements were false or acted with reckless disregard for whether they were true or false. This is how people making MeToo allegations against public figures in the USA do so at less risk than they do here in Australia. While making sexual misconduct allegations carries a risk of litigation no matter where you are, people who make MeToo allegations here are at extreme risk of being sued and bankrupted. You're probably aware that whether it's in the civil or criminal courts, proving sexual misconduct is difficult where there is little or no corroborating evidence, and it comes down to one person's word against another or others. Damages can be mitigated by removing material from publication, publishing a correction or retraction and apology. The court takes this into account when awarding money to the plaintiff for reputational damage and hurt feelings. It can significantly reduce the amount a defendant might have to pay if they're unable to defend their publication. A large number of defamation claims never make it to trial. They are often settled out of court via correspondence between legal representatives or in mediation. It's often the case that a plaintiff will settle for the defendant removing the publications, publishing an apology and a correction, and paying the plaintiff some amount in damages and reimbursing their legal costs. There can be serious consequences for unreasonably refusing an offer of settlement.
In Serge Benhayon's case, it was found by the court that he had unreasonably failed to accept an offer of settlement that I made, and for that reason he was ordered to pay my legal bills on the indemnity basis rather than the standard basis. And what that means is that he had to pay the highest possible proportion of my legal bills. And it's worth bearing in mind for defendants that the court you might win your case, but you won't be compensated for all of your legal costs.
These are the defences available under the Defamation Act. I'm not going into all of them, only the ones that are most commonly relied on by defendants in Australian courts. You only need one defence to succeed for each publication. The strongest and most satisfying defence is truth or justification. In Benhayon v. Rockett, I pleaded all of these defences and all of them succeeded. The qualified privilege defence succeeded for all the publications. The truth defence succeeded for all but 4 imputations. The honest opinion defence for all but 2 imputations. This was regarded in the legal world as a huge win. Taking a defence of truth to trial is expensive because the court must spend a lot of time on examining evidence, and it's rare for the truth defence to succeed for so many imputations. So this is the defence of justification, or the truth defence, Section 25 of the Defamation Act. It is a defence to the publication of defamatory matter if the defendant proves that the defamatory imputations carried by the matter of which the plaintiff complains are substantially true. And as I said, in some overseas countries such as the USA, the burden is on the plaintiff to prove that the allegations are false. But in Australia, publishers need to be aware that the onus is on the defendant to prove the truth of the imputations. And as I said, those imputations are decided by the plaintiff. In determining the truth of an allegation, there is a difference between civil and criminal burdens of proof. To convict a person of any criminal offence, a court must be satisfied that a charge is proven true beyond reasonable doubt. In civil courts, the burden of proof is slightly less. To establish that an allegedly defamatory imputation is substantially true, it must be proven true on the balance of probabilities, with clear and cogent evidence. Apparently, universal medicine followers are choosing to remain in denial about the court's findings. They've been making statements saying there's no evidence of wrongdoing on the part of Serge Benhayon and that the findings of fact in the civil courts don't count.
Jonathan wasn't there. The court heard 3 weeks of evidence, including from Benhayon himself, and Serge Benhayon did not appeal the finding.
The court made an order during the trial that the Briginshaw principle had to be applied to some of the most serious imputations. What that means is that the jury were told they had to be very satisfied that there was clear and cogent evidence to prove that the imputations are true. Whether it's the civil or criminal burden of proof, I'd like to remind you that ideally you don't publish allegations unless you have reliable witnesses who are willing to testify and or documents, writings, recordings, images that are capable of proving the truth of your statements. When an imputation is proven true in court, the plaintiff can never sue anyone again for repeating that imputation. And I'll briefly discuss the Section 33 defence of triviality. This defence applies for where publication is very small scale or minor. It is a defence to the publication of defamatory matter if the defendant proves that the circumstances of publication were such that the plaintiff was unlikely to sustain any harm. An example of this might be where someone sends an email with defamatory statements to a couple of people, and those people, if they read it, did not find it credible. There's a group of immunity, or you might call them privilege defences, for certain types of communication. In these defences, it's not necessary to prove that the information you convey is true. Looking at the Defamation Act, those are there numbered 27, 28, 29 and 30. An example of absolute privilege is a Member of Parliament using parliamentary privilege to air some allegations. Senator Nick Xenophon did this to get stuck into the Church of Scientology. If you have to testify in court or at a tribunal or give a statement to an official investigation, that's an occasion of absolute privilege. You can't be sued for the statement you make. So the absolute privilege defence recognises that at times witnesses don't come forward because they fear being sued if they tell the truth. These defences allow witnesses to tell the truth to official investigations or inquiries or proceedings without that fear. But where people do not tell the truth, there are separate penalties for perjury or for making false statements to authorities. Under sections 28 and 29, you can make a fair and accurate report of evidence given in an open court or tribunal. Those are what is meant by proceedings of public concern. Public documents are things like judgments published by a court or a parliamentary report. Bear in mind that other courts, such as the Family Court and the Children's Court, are closed, and reporting on those proceedings is prohibited. The next on the list is the Section 30 defence, which I pleaded and was successful in defending all of my publications. You may have a qualified privilege in communicating certain information. Without reading the whole section, the privilege applies if you are providing information to people with a genuine interest in receiving that information. There is a public interest in you doing so, and you go about it reasonably in the circumstances. It's also known as the reasonableness defence. But this defence is not available to media organisations. The court holds media organisations to a high standard of accuracy in reporting and consider it unreasonable if a media organisation publishes material that turns out to be inaccurate.
While a qualified privilege defence allows for some inaccuracies, as long as you published reasonably, it's risky, and it's not a defence you want to rely on primarily.
A defendant who pleads a defence of qualified privilege will need to bring evidence of the circumstances of publication. Without reading the whole thing, the defendant will need to establish that it was a matter of public interest and of such importance that it needed to be published, and that the defendant made some effort to verify the facts. It helps if the defendant sought the other side of the story and a response from the other person. It was determined that there was a public interest in my communicating information to people who read my blogs or Twitter accounts and therefore have an interest in universal medicine. Taking the circumstances into account, the court found that I behaved reasonably in publishing. In determining reasonableness, I gave evidence that I had conducted thorough research, had communicated with people who'd been directly affected by UM, taken complaints to authorities and provided evidence. I also gave evidence of my background, profession and education and how those informed my concerns. I worked as a health professional and had studied cults as part of a major in religious studies. I gave evidence of UM's behaviours, their refusal to engage in dialogue or answer questions, their public attacks on critics, and their attempts to silence truths. It also probably helped that I proved all but 4 imputations are substantially true. A defence of qualified privilege is defeated by malice.
Malice in the civil courts is a little bit different to the ordinary meaning.
Malice is understood in defamation law as having an improper purpose in publishing, such as an intention to harm the plaintiff. Publishing falsehoods knowingly is evidence of malice, or having reckless indifference to the truth. Even here, though, it's said that recklessness in publishing does not prove the defendant knew the allegations were false. But under the law, a defendant can't get away with wilful blindness to the truth. In other words, a defendant can't pretend something is true when it clearly isn't, or vice versa. This is an example of willful blindness. I drew attention to these images of Serge Benhayon, and in the lower image his hand is seen on a woman's genital area. The text refers to this technique as great for cases of rape recovery. Universal Medicine and a number of its followers published statements that I'm ignorant about anatomy and that I lied in identifying the anatomical location, and that Benhayon's hand is nowhere near the woman's genitals. We can all plainly see where his hand is, and to eliminate all doubt, I asked my medical expert to identify that anatomical location for the court. In my opinion, those denials by UM amount to willful blindness. It's not listed in the Defamation Act, but there is one more defence of qualified privilege at common law. It's also known as the defence of reply to attack.
This is where a defendant might be replying to nasty things the plaintiff has published about them. But again, this defence is defeated by malice. So if the defendant has published statements they know are not true or are willfully blind to the truth, the defence will fail.
Next is Section 31, the defence of honest opinion. It is a defence to the publication of defamatory matter if the defendant proves that A. the matter was an expression of opinion of the defendant rather than a statement of fact, and B. the opinion related to a matter of public interest, and C. the opinion is based on proper material. All of those 3 factors have to be present. I touched on this early in the presentation. It helps if publishers use qualifiers such as "in my opinion" if they are publishing about controversial activities or materials. A publisher needs to bring evidence to the court of the proper materials they've based their opinions on, or prove the facts that they based their opinions on. The defence of honest opinion is defeated if and only if the plaintiff proves that the opinion was not honestly held by the defendant at the time the defamatory matter was published. This part tells us what proper material is. It must be true, as in the proper material is material facts that are notorious or able to be proven. Otherwise, materials that can be authenticated. For example, I might say that I think Eddie Obeid is an untrustworthy person because he's been found guilty of corruption. That is an opinion based on a notorious fact. Another example of proper material is Benhayon's publications. Although the things Benhayon and UM say in their publications may not be true, it is true that they say them. The proper material must form a rational basis for the opinion expressed. For example, the image we saw earlier was proper material to form an opinion that the touching and the healing claims shown in it were inappropriate. I was able to authenticate that material in court.
You need to include proper material for your opinion within your publication. Within mine, I provided examples of Universal Medicine's materials or links to those. And if you're relying on facts, you need to identify those facts within your publication.
This is an example of a publication that was successfully defended by the defence of honest opinion. The facts or proper material was referred to within the publication. The tweet contained a link to one of my blogs, where I provided lots of quotes from Benhayon's publications, as well as images like the one we saw earlier that showed Universal Medicine's commercial activities include this bizarre sexual manipulation.
In fact, prior to starting my blogs, I read defamation law. And that's why some of my blog posts are really pretty long and maybe sometimes a bit too long if you're trying to get through them. But really what I was doing was covering myself legally by providing the proper materials to back my opinions.
This series of questions to the jury in Benhayon versus Rockett shows the process the court uses to decide whether a defence of honest opinion is upheld. Has Esther Rockett established that such imputation was carried as her own opinion rather than as a statement of fact? Has Esther Rockett established that such an opinion was based only on material within any of the following matters and no other material? Has Esther Rockett established that all of the material on which such an opinion was based was substantially true? If not, has she established that such an opinion might reasonably have been based on as much of the material contained within the following matters as is substantially true? Has Serge Benhayon established that Esther Rockett did not honestly hold such an opinion? In contrast, this is an example of some of the material published on Universal Medicine's website. This passage was published in 2016. This and all similar publications were taken down after the trial of Benhayon versus Rockett, and if you've learned anything about defamation law, you can probably see why. Universal Medicine persistently published false allegations that I was a liar and a vexatious complainant who had fabricated complaints to authorities and never provided any evidence to back them. I believe the defence of honest opinion would fail for these publications because the statements were assertions of fact rather than expressions of opinion. They did not identify any facts or proper materials within the publications or rely on any.
Once in a while they would refer to the fact that the authorities had not investigated some of my complaints and had dismissed them. But that's not a rational basis to come to any of those conclusions and make those statements. And in fact, the authorities had investigated and acted upon several of my complaints. And some of the publishers knew this when they published.
Best practice is to make sure you have material evidence to back you. Witnesses willing to testify and documents, the more the better. At least, if you're publishing an opinion, point out that's what it is and show that you have a proper basis for that opinion and provide that material in or with your publication, or at least identify the facts you are relying on. Otherwise, the consequences can be very expensive. Broadcaster Alan Jones accused these Wagner brothers of causing the Grantham flood disaster that killed 25 people. He did so after a government inquiry cleared the Wagners of any fault. Jones was not able to bring any evidence or witnesses capable of proving the allegations he made. The court found that he had no proper material or facts to to rationally base his opinion on. He attempted to claim that he had relied on experts and local witnesses, but those persons were not found to be reliable sources of facts about the disaster. As you see from the report, the court ruled that he was wilfully blind to the truth. The Wagner family in this case were awarded aggravated damages because Alan Jones continued to repeat the defamations without any evidence they were true, and the judge remarked that Jones was motivated by a desire to injure the reputations of the Wagner brothers and did so viciously and unjustifiably. Don't let that be you. There's lots of resources out there to help you understand the laws around publishing. Mark Pearson is a professor of journalism and social media at Griffith University and has written this book especially for internet publishers. It might be worth looking for. He's also written a book called The Journalist's Guide to Media Law. As I said at the beginning, stick to facts and proper materials. You need to think carefully before using contentious terms that are difficult to prove or justify. Terms like brainwashing, cult, allegations of mental illness, fraud, liar, or allegations of criminality, they're all difficult to prove. If in doubt, seek professional legal advice before you publish.
So that's it for this presentation. I've made part 2, where I'm going to be talking about cases to illustrate some of the things I've been talking about in this presentation, how the law plays out and how some of these defences work and don't work, and the kind of damages that are awarded to people who are defamed. So thank you for joining me. I hope you'll join me for part 2, and happy publishing.